Well, look what we have here. It's the law firm of Dennis Block and Associates, and we're having another podcast. Today is May 26th, 2019, the day before Memorial Day, and I've got a new co-host. Can you believe it? His name is Ryan Block. Hello, Ryan.
Hey, how you doing?
I'm doing really good. Ryan is actually my son, and he is an associate in my office. Ryan, how long have you been an attorney?
About 4 years now.
4 years. And what's your primary function at this law firm?
I do trials. I go to court every single day, going from anywhere from Ventura all the way to Long Beach, just depending on whatever we need.
And how many trials would you say you have done in your short career of a 4-year as an associate at the firm?
Definitely over a couple hundred trials that I've actually gone forward, including about 6 or 7 jury trials that have also gone forward until a verdict.
Well, that's great. So let me ask you something. Was it a big transition between going to law school and then actually getting out, passing the bar, and actually practicing law and being a litigator such as you are?
Absolutely. Law school just teaches you how to pass the bar, but actually being in the office and going to court actually teaches you how to be an attorney. So, you get some experience going to law school, but most of it comes from actually being in the field.
Now, this firm obviously represents landlords in tenant eviction cases. And what would you say the flavor in terms of the bias of judges are? The judges tend to be fair, neutral. As we've learned in law school, judges are supposed to be neutral and apply the facts to the law. And what would you say your experience has been?
A good judge, in our experience, is someone who is neutral. So that would mean that most judges are kind of swinging towards tenants. And that's not just the judges. It seems like a lot of the laws are very favorable towards tenants, which causes a big setback for landlords as well as attorneys who represent landlords in court. So it's a big problem.
Have you ever seen any judge just do some outrageous decision?
Absolutely. If the judge doesn't like the case, I've seen judges that will basically kind of try to tarnish the landlord's case in order to favor the tenant so that the tenant will win the case.
Overall, do you think landlords get a fair shake in a court?
It really depends on the judge. I mean, if you get a fair judge, then you have a decent shot. But so you really have to be very careful, and it's good that we get or every side gets a 170.6, which basically allows an attorney to say no to one judge. And if you get a bad judge, you can say no to that judge. So it's important to save that peremptory challenge to that judge so that hopefully the second judge you get will be good, assuming that the first is not so good.
So would you say there's a little bit of gamesmanship with regard to the practice of law?
Definitely. Everything has to be very strategic. You not only have to have the facts on your side, but you also have to show a way that maybe some sympathy for your client, maybe show that there's a reason that he should be sympathetic as well, not just the tenant, which is what seems to happen a lot.
And do you find it rewarding being a litigating attorney?
I do. I really like it because it's very challenging to kind of be a couple steps behind from the get-go and try to climb your way back and win the case. So it's definitely a fun thing to do, and I really do believe what we're doing. It seems like everybody's kind of against the landlords, so we seem to be the voice for the landlords, so I really do like that.
Well, that's great. Normally the format of these podcasts is that we go over some of the questions that have appear in the Apartment Owners Association magazine, and we kind of address them a little bit more fully. Anybody who's going to hear some of the questions we're asking today actually won't appear in the magazine until the June issue, so you guys who are listening today are actually going to get a preview of those questions. So why don't we start it right now? Why don't you ask the first question, then I'll see if I can answer it, and then of course if you've got some response to it or other comments, please feel free to do so.
Okay, so question one is, I have a rent-controlled unit in the city of Los Angeles. I'm considering doing short-term leasing once the unit is vacated. I tend to use a service such as Airbnb. Are there any pitfalls or suggestions that I should be aware of? I feel that I'm forced to do this as my long-term tenants pay such little rent. Short-term rentals appears to be the only method which allow my building to become profitable.
And that is really an important question in that you have buildings that the landlords are limited in terms of what they can charge for rent due to the rent control statute. And obviously, you're basically supporting a certain percentage of the tenants based on the rents that they're paying, which is clearly not market value. So a lot of landlords have turned to the issue of using Airbnb, where they can actually get a fantastic amount of rent for a specific unit, renting it for short-term rentals. But the city now has made a new law. And in some respects, the law is good for landlords whose tenants are using Airbnb, using their apartments for short-term rentals where they're leasing it out. And this new law goes into effect on July 1st. And what the law says is that you cannot, whether it's a single-family home or multi-unit, makes no difference, you cannot do short-term leasing in the city of Los Angeles unless the unit that you're leasing is your primary residence, And if in fact it is your primary residence, you're limited to only 120 days per year. So many times we run across landlords who are getting very small amount of rent for a specific unit, let's say $800, when of course the unit could literally go for $1,900 to $2,000. But the tenants are in the business of being landlords. So what they're doing is they're going on Airbnb and leasing out their units, and of course they're making literally more money on the units than the landlords are. Well, in this respect, the law is clearly going to clamp down on those individuals in that the landlord, number one, usually has a provision in their lease which prohibits subleasing, but also it's going to limit the tenant, even if there isn't a limitation, to only 120 days. The other side of the coin is that if a landlord now wants to rent out a vacant unit, not put it onto the market, but just do Airbnb or a similar service, now he's limited to only if that's his primary residence. So right now what this law will do come July 1st is it will prohibit any landlord from putting their units up on rental for short-term leases, as it's called.
Yeah, it's kind of interesting. I think it's going to be very difficult to determine how, if 120 days are spent, and how do you prove who's, that that's their primary residence or not. It seems like it's going to be an issue to, show that they've violated this law.
Well, for the landlord point of view, if a tenant is doing that, we always can use the situation of the rental agreement to enforce the terms of the rental agreement, which would prohibit subleasing. So in that situation, we have a clever thing that we do in our practice here, is that we'll serve on the tenant a 3-day notice to stop subleasing. And most of the time, landlords find it difficult to prove because the tenant's going to say, well, this is a friend of mine, I'm not subleasing it. Even if the tenant, even if you can show that they have advertisements on Airbnb, it's still difficult to prove that that person is subrenting. Also, by the time the case gets to court, that person's going to long be gone. So really, how do you prove it? So what we've used in our practice here is we'll serve the tenant with a 3-day notice to prohibit subleasing, giving him 3 days to do it. And then what we do is we have the landlord literally have a friend rent the unit about a week to 10 days later. So by doing that, the friend obviously will go to that unit, will open the door, take some pictures, put their luggage down, and then of course immediately walk out, because now the tenant has violated the terms of their 3-day notice by continuing to sublease after that notice expires. The problem though is for landlords who are trying to make some money on their buildings but are dealing with rent-controlled units, that now they're somewhat stuck from doing any Airbnb. Now, why don't you tell our listeners the situation that your brother is going through right next to him?
So, one of his neighbors is renting out their house. It's a single-family home, and it's on a kind of like a quiet street, but they have a bunch of partiers coming in every night, and they're renting it relatively low for the value. It's I think a 5,000 square foot house. They're only renting it for like $500 a night, $600 a night, which is causing a lot of partiers to come and kind of bother everybody, and it's causing kind of a nuisance on the street. So my brother's not too happy about that.
That is true, but I think that, and of course we've been considering filing a lawsuit against the homeowner on the basis that what he's doing is creating a nuisance for the neighborhood, including your brother Brandon. However, come July 1st, we have an easy resolution, and one of the questions you asked was, how do we prove it? Well, all we're going to need to do now is come July 1st, since that house is not that person's primary residence, as soon as he leases it out to an Airbnb, we can call now the city attorney's office, and they will come down and cite him based on this new law. The concept for the city and why they created this short-term or home sharing statute is based on the fact that they don't want to cut down rentals in the city of Los Angeles. They want as many places as there can be, because they believe that there's a housing shortage. So because of that, they've created these rules dealing with the short-term rentals and what you can and cannot do. Let's move on to question 2.
I recently purchased an 8-unit building in Hawthorne. The laundry room has a coin-operated washer and dryer. I contacted the laundry company and told them that I would not be using their machines and asked them to be removed. They informed me that they had signed a 10-year lease with the previous owner, which has 2 additional 10-year options. Am I obligated to have them in my building for over 20 more years?
Well, here's the problem. When you buy a piece of real estate, any existing leases run with the land. And what that means is that you're taking that property subject to that lease. So if there's, for example, a tenant in a commercial building that has a 20-year lease, the fact that you're purchasing that building doesn't mean that the rental agreement is torn up. So these washer companies will have landlords sign these leases that have what they call these automatic renewal provisions, and landlords, of course, just sign them. So I caution anybody out there who's considering leasing to these laundry companies, your laundry room, that you understand that number one, make sure that there's no automatic renewal provisions, because you're stuck with whatever this lease says. And if you read these leases, one of them's by Dotson Washer, and there's a bunch, but they're all basically the same, where if you sign it, the lessee, and that's the laundry company, has 2 more option periods, and usually these option periods are 10 years. So literally you're signing an agreement for over 30 years that this person can operate laundry equipment unless they want to get out. Of course, that's what the contract says. They have the right to terminate if they want to. And generally, the amount of money that's generated to the landlord is very small. The accounting is somewhat sketchy. So the landlords feel like they've got people in their building that are not in any way contributing to the income of the building. So if you buy a building and there is a laundry contract in place, take a look at that before closing escrow and understand what your rights and obligations are. If you're ever dealing with a potential of leasing out your laundry room to any of these companies, make sure that the term is very low, that you're only going to do maybe 3 years at the most or 5 years, but at the very minimum that there's no automatic renewal provisions.
Agreed. And also, in some of these leases, you should have them carefully read over by an attorney, or if you can read it yourself, because sometimes you'll have to send them a cancellation by a certain time, or it will automatically renew, so you have to jump on it and make sure that you don't trigger an automatic renew if you are trying to cancel it. Okay, so I'm going to go on to question number 3, which says that I have a building in Los Angeles which is required to have soft retrofitting for earthquake safety. I got a bid from a company and the cost is over $100,000. My building is under rent control and I do not see how I can afford this additional expense. Are the tenants responsible for some of these costs?
Well, for a safety issue, the city created this soft retrofit statute where, based on the configuration of your building, many buildings in Los Angeles require this soft retrofitting. They've given us 7 years to do so. I know I had a building, or have a building in Studio City which did require it. I had to get a bid from a company. It wasn't, it was pretty close to $100,000. And you're dealing with the unfairness of being limited in terms of what you can charge for rent, and yet you're told that you have to make this incredible expenditure to bring your building to earthquake safety code levels. So it's really a catch-22 where some owners are just selling their buildings because they really have no choice. But the city did give us this is the city of Los Angeles, did give us some retribution in that we can ask the tenants to pay 50% of the cost of the retrofitting, but it is amortized over a 5-year period between all of the units. So for example, if you have 10 units and the amount of the job was $100,000, those 10 units would be responsible for half that cost, which would be $50,000, or $5,000 a unit. And the $5,000 would be paid amortized over 5 years. So whatever that rate is, it would probably be like $1,000 per year divided by 12. And that would be what the tenant's rent would increase. So you do get some of it back, but literally for some landlords who are struggling with mortgage payments, you have property taxes, you've got expenses of the building not relating to the soft retrofit, and now all of a sudden you're looking at a $100,000 price tag. Well, no wonder why landlords are struggling in our economy now.
Yeah. So I have a question for you, Dennis.
Cool.
If it was approved by the city so that the tenants would have to pay more money, and then the tenants decided not to pay, would that be considered part of their rent, or would that be considered part of the conditions of their lease? Would it be a 3-day notice to pay rent or quit, or a 3-day notice to perform or quit, based on the city's obligation for them to pay if they were not to pay that extra money?
This is under the concept of what they call capital improvements, and it is considered rent. So you're allowed to increase the rent by that amount under that formula of 5 years, amortized over 5 years. Now, so if the tenant didn't pay it, let's just pretend they paid the base rent, but they didn't pay this capital expenditure, then you'd serve a 3-day notice. Now, one thing you want to be careful on is that at the end of a year, when you're ready to increase your rent, and you're going to do, and by the way, everybody, July 1st, the city has allowed us a 4% rent increase for rent-controlled units. But in that situation, you want to make sure that you only did the 4% rent increase on the base rent, not on the capital improvement. But again, to answer your question, if you don't pay that capital improvement, it would be a 3-day notice, and then we'd be able to proceed forward with an eviction.
Got it. And also, I'd recommend that if you are going to serve a 3-day notice, that includes that charge in it. I would probably attach the approval letter from the Housing and Community Investment Department just to cover your bases if it ever were to go to trial.
Sounds good.
Question 4. I have a property in unincorporated area of Los Angeles. I know that my building is under rent control. I have a tenant who is not paying rent. I attended your seminar in Long Beach at the AOA trade show. I remember that you mentioned that there are special rules in serving a 3-day notice. Can you go over these again? Thank you.
Yes, the unincorporated area of LA County now created rent control for every unit, which 2 or more on a property. If you go to the LA County Voting District website, you'd be able to punch in your address and you would see whether it comes up your property is located in an unincorporated area. If your property is in an unincorporated area and you thought you were clever buying it there because you weren't under rent control, unfortunately the law has now changed and we're now subject to rent control. But the the county supervisors insidiously have put in a poison pill. And this is the poison pill. Normally what you would do is if a tenant didn't pay you the rent, it's not a matter of increasing the rent, just straight, you didn't pay me the rent, you would serve a 3-day notice on that tenant, and then you'd wait your 3 days. Thereafter, you would then file an eviction lawsuit. If you did that, you've already lost your case based on the poison pill that the county supervisors have included in with this ordinance. And what the ordinance states is that after you serve the tenant, and it's by the regular method of serving, within 5 days of the service of the notice on the tenant, you have to mail a copy of that notice and the proof of service of that notice to the county. Not just mail it regularly, you've got to mail it by certified mail, return receipt requested. That's going to be a big defense for any tenant who can determine that, well, yes, I got served with the notice, he put it in my hand, but the landlord within 5 days of that act did not mail a copy of that notice and a proof of service to the county, certified mail, return receipt requested. It's almost like the county is trying to figure out a way that landlords will make a mistake and therefore will lose their case. Now, the county is probably saying that, well, we're concerned that landlords are pretending to serve notices but really don't serve them. I mean, it's a total gaming situation where the supervisors are really trying to allow tenants to stay in your property much longer without paying rent.
Yeah, I mean, that law makes absolutely no sense, and a landlord could hypothetically even just serve the county if they wanted to anyways and not serve the tenants if that were the case. So I think there's really no basis for this law. It just seems like a way to have another out for a tenant, and that just goes again with part of these laws that are just very favorable towards tenants. Question 5. I have a duplex in the city of LA, which is under rent control. My rents are way below market, and I'm considering demolishing to put up the new units. According to the building department, I could construct a 6-unit building. What are the steps that I have to take to remove the existing tenants, and do I have to pay relocation fees?
Well, this is under the concept of called the Ellis Act. That's a state law which states that landlords have the absolute right to permanently remove their units from rental housing use. Most of the time, that means that it's going to be a developer who's going to demolish the property and to put up more units. And literally, it's the only way in some situations where a landlord can feasibly get a decent return for his investment. I mean, a person can buy a duplex where you have two long-term tenants in there, and literally, based on the new real estate taxes that are involved and the maintenance, you literally make no money. So investors out there are using the concept of the Ellis Act to make it a profitable way of running that property. So what's involved? Number one, you have to go through an application process. With the city of Los Angeles, for example, they have paperwork that needs to be filed with them. You also have to literally, once it's approved, you literally have to record against the title to your property that you're permanently removing those units from rental housing use. That would prevent somebody from basically evicting all the tenants, then selling the building, and the unsuspecting new owner would say, gee, I can rent these out for whatever I want. So literally, against the title of the building, you have to record the fact that this is now an Ellis Act building where it's permanently off of rental housing use. Once that's all approved, then you need to serve on your tenant a notice to quit. The notice to quit is 120 days, 120 days, unless one of your tenants is over 62 years of age or older or handicapped. In that situation, the tenant can opt for 1 year's notice, 1 year's notice. So you also, of course, have to pay relocation money. The relocation money is anywhere between $8,000 to $20,450 per unit. So you have to, if you're going to use this situation, you have to make sure that you've figured this out, exactly what you intend to do with the property, and that it's going to, zoning wise, make sense to build the amount of units that you want to do it. But it is certainly a wonderful remedy that you can use to get rid of units that are not producing potential income and get yourself a new building in there. Now, believe it or not, in some situations going back, it made sense because the law used to say that if your permanent removal means that you take it off of rental housing use for 5 years. So for example, in that duplex situation where maybe you're getting $300 for each of those 2 units, crazy, maybe it would make sense to go through the Ellis Act and withdraw it from rental housing use for 5 years. At the end of the 5-year period, then you'd be able to re-put it on the market again and also then get market rent. You're still under rent control, by the way, but at least you'd be able to get market rent for the first tenants coming in. So many landlords would do that. Maybe they'd put their friends in it for no rent. Maybe they'd put their children in it and wait the 5 years. Well, unfortunately, that wonderful remedy has now been thrown out the window because now the city says it has to be for permanent removal, you have to withdraw it from the rental housing use for now a total of 10 years. So now it doesn't make any sense. But our firm, as you know, does literally hundreds of Ellis Act evictions where we go in there, we permanently remove these units from rental housing use. We have a situation now real close to Culver City in the Palms area where one of our clients has 64 units. And he is going to do an Ellis Act on those 64 units, and he's going to put up 160 units. So if you have a situation where it just economically doesn't make sense, that is a potential method of saving yourself by considering to literally demolish the building and put in additional units.
So is this person, he's going to take it off the market for 10 years and build 160 units? What is he going to do in the meantime with those units?
No, you don't have to take it off for 10 years. If you wanted to do nothing with it, then in 10 years you'd be able to re-rent those same units. Obviously, he's going to immediately, once we evict these tenants, he's immediately going to demolish the premises and start the building. So he'll basically have 160 units, and it makes sense, even if he's going to be giving anywhere from $8,000 to $20,000 per those 64 units. So for him, it makes total sense to do it, and he's going to have himself a very valuable and a new piece of property.
So once you demolish it, then it gets rid of the restriction of permanently taking off for rental.
That is correct, because you're never going to rent out that specific unit again. It doesn't exist, because now there's a new building there. Now, people don't understand though, when you build that new building, even though, quote, it's new construction, it's got a new certificate of occupancy, so most people are going to think that that is not under rent control anymore. But the truth of the matter is that while you're able to rent it out for the first tenant coming in at market level, you still are subject now to rent control because you use the Ellis stack. But again, for most investors, it really doesn't make a difference. If you can get market rent for your property, the fact that thereafter it's under rent control really means very little.
Right, because you're going to be keeping up with the 3 or 4% rent increases every year, and it should not be too detrimental, but not as good as it would be without rent control.
Anyway, I think this was pretty good for our first landlord-tenant podcast. What do you think?
Yeah, it was fun.
Yeah? Maybe we'll do it again soon, like in 2 weeks. But in any event, my name is Dennis Block, and this is my associate and son, Ryan Block. If anybody ever needs to get in touch with us, feel free to call our toll-free number, which is right over my left shoulder, 1-800-77-EVICT. We have a wonderful website. It's evict123.com. That's EVICT 123.com. You can listen to these podcasts, and we have all of our free forms and instructional videos, and you can even start a case. So, with further ado, I want to thank everybody and see you soon.